often overlooked as an influence on his international approach, was one which stemmed from his view that the Australian Constitution was outdated and needed to be changed. In Whitlam's view, such changes could be achieved in part by adopting international treaties that would then need to be reflected in the domestic law of Australia. Speaking at the Australian Convention, Whitlam said of the Constitution, the Australian Legal Convention, it's accepted. It is by accepting our international obligations as responsible members of our world that we may aspire in truth to be one nation. A basic weakness of the Constitution, as Whitlam saw it, was its failure to address the workings of the democratic system and to guarantee democratic rights for all Australians. The use of the external affairs power was never far from his mind, as his interventions in Parliament frequently indicate, even before he was elected as Prime Minister. Whitlam's interests in modernising the Australian Constitution also recognised the significant effort that former Prime Minister John Curtin had made and the impact of Curtin on his political views regarding the Constitution. His view of the external affairs power was extremely heretical at the time of its first expression by Gough Whitlam and when it was forming in his mind. However, a series of decisions by the High Court of Australia in the last 50 years has undoubtedly confirmed that Gough Whitlam's opinion on the ambit of the external affairs power was legally correct and sustained a very broad range of measures based on bringing into effect in Australia international treaties to which the nation had subscribed. Following his dismissal from the office of Prime Minister on the 11th of November 1975, Whitlam has continued to advocate an internationalist outlook on the part of Australia, its institutions and people. It is a part and parcel of his public persona. The Whitlam Institute has been created within the University of Western Sydney to collect the materials, provide the sources, encourage the civic discourse and maintain the attention of the Australian public towards the grand themes of Gough Whitlam's life. Those themes are not confined to internationalism, still less are they confined to international law or human rights. His fertile mind gave rise to very many projects: Australia's relations with Asia, justice for our Indigenous peoples, institutional law reform, better housing services in suburban Australia, national environmental protection, multiculturalism at home, independence in foreign relations, engagement with Asia and the Pacific, concern for the arts and for culture, secularism in public life, constitutional reform, and building a joyful, confident, healthy and well-educated multicultural nation, a nation such as can on Saturday night celebrate in this city the Mardi Gras parade to which reference was made at the outset by Peter Waters. This lecture by me has addressed one facet only of the broad political and intellectual interests of E.G. Whitlam, yet it has been an important and influential element, and I suggest it was one in harmony with the age. There were mistakes and failings, that's true. Although he himself might sometimes dispute the assertion, Gough Whitlam was, after all, just human like the rest of us. He made errors, and he was sometimes inconsistent. Yet beside the achievements and the nation-changing reforms that he helped to introduce, those errors and faults can be seen at this remove and perspective in a proper light. Whitlam was a change agent necessary to his times. The shift in Australia's perception of itself and of its place in the world was essential, and indeed by the year 1972 it was long overdue. The lives of millions of Australians were touched by Gough Whitlam and his government. After Whitlam, it can truly be said Australia was never quite the same country again. And in the long eye of history, perhaps the most important change he brought about was the radical re-engagement he achieved with Australia's place in the world, and the confidence that he installed in Australians that they could play a useful part in securing a safer, more equitable and rights-respecting world and nation, just as the United Nations Charter envisaged. Throughout his life, like a thread of Ariadne, was spun an interest in the world and in international institutions and international affairs. It did not lead him to the Minotaur, it led him to a stronger, more confident and just Australia.
Speaking of your experience of the way in which Australia's ratification of international agreements such as human rights agreements was then able to be used through in judicial roles that you've had.
Well, that question requires an answer in 3 parts. The first is, to what extent has it contributed to decisions where the case concerns the implementation in Australia of a treaty which directly or indirectly has been made part of Australian law by a statute? The answer there is it has contributed enormously to the development of Australian law. Take, for example, the Refugees Convention, which is being examined virtually every day in courts and tribunals throughout the country. To find what that means, you go to the treaty and then you go to the jurisprudence that has developed around the treaty. No question, no problem. Plenty of use in that area. The second category relates to the common law. To what extent have the treaties affected the development of the common law? That was something which I suggested in a number of decisions in the 1980s when I was President of the Court of Appeal. And in 1992, in the great Mabo decision of the High Court of Australia, the majority held that they were authorised and required to change the expression of the common law in Australia concerning the previous law that Australian Aboriginals had lost entirely their title to their traditional lands by reference to the international instruments, the international treaties. And in the reasoning of the High Court, it was said that such a principle of the common law of Australia did not stand with international law on universal rights and values, and that therefore it demanded to be reconsidered. And therefore, in the second category, there is no doubt that in the common law, it is legitimate to have regard to the international treaties, at least in relation to the universal principles of human rights, just as the Mabo decision held. The third category relates to the Constitution. Can you use ratification of treaties in any way to consider the meaning of our Australian Constitution? This has been a hotly debated issue in the High Court of Australia. There was a celebrated exchange between Justice Michael McHugh and myself in a case called Al-Khatib against Godwin. Justice McHugh saying that that was entirely theoretical and in fact heretical, and I saying that it is now part of the context in which the Australian Constitution has to be interpreted, that our Constitution speaks to us of the type of nation we are, but also speaks to the world of the type of nation Australia is. In a recent decision concerning the right of prisoners to vote in federal elections under the Australian Constitution, the case was Roach against the Electoral Commissioner, the majority in the High Court, who held that you could not take away from prisoners, from all prisoners, the right to vote, referred to international human rights decisions in decisions of Canada, the Supreme Court of Canada, and decisions of the European Court of Human Rights. That was strongly contested by dissenting Justices Hayne and Hayden, but the majority made those references as a contextual element in the course of their reasoning.